We're going to go ahead and move on. Assessor Stone will now kick off our Prop 19 update today by sharing some important background information and then introducing our speaker on the topic. Thank you, Assessor Stone.
Well, since the passage of Proposition 13 in 1978, assessed values are no longer market-driven. Assessments are based upon the purchase price at the change of ownership or new construction, and then increased by no more than 2% a year. That's Proposition 13. As a result, assessed values over time are far less than market values. One's low assessment has become a prized asset, cherished by longtime homeowners, and envied or even despised by younger, first-time homeowner wannabes. Over time, the voters have approved several ballot measures intended to retain low assessments, even passing assessed values on to their children, and in some cases, even to their grandchildren. Proposition 19 is the latest effort in that regard, but it, unlike its predecessors, was terribly written. For more than 2 decades, I've administered the property tax system in Santa Clara County based upon a simple premise that there were clear rules of the road. Proposition 19 contained major changes to the state constitution, overhauling or eliminating 5 previous initiatives. Many of the provisions were confusing, ambiguous, and were in conflict with the initial intent. To make matters worse, the ballot initiative did not include any implementing legislation. So to understand where we are today, it's important to know how we got here. For decades, with little success, there have been attempts to expand Proposition 60, the initiative passed in 1986, which enabled homeowners over the very old age of 55 to transfer their coveted assessed value to another home of equal or lesser value without reassessment to market value. Prop 60 principally was designed for empty nesters wishing to downsize, and it was relatively straightforward. 2 years later, the voters passed Proposition 90, expanding this benefit to other counties. However, the inter-county transfer allowed each county to choose whether to participate or not. Well, not surprising, only 10 counties of 58 agreed to accept Proposition 90 transfers. The reason? Well, the loss of property tax revenue. Proposition 19 was sponsored by California realtors for the primary purpose that it would create more transactions and therefore more real estate commissions. In 2018, California realtors qualified Proposition 5 for the ballot, allowing transfers to all 58 counties. The realtors' proposal, however, was a non-starter for parents and others concerned about the huge loss in revenue estimated by the Legislative Analyst's Office to be $1 billion a year, negatively impacting funding for schools and local government. Proposition 5 was also allowed homeowners over the age of 55 to purchase a larger, more expensive home in any of the 58 California counties and retain most of their property tax benefits, defeating the original intent to assist empty nesters, seniors who want to downsize from a larger home, or to enable grandma to get closer to the grandkids. Proposition 5 failed by a margin of 60 to 40. Cutting funding for public education was a bigger concern for schools and labor unions than the additional tax cut for longtime property owners already benefiting from Proposition 13. In addition, firefighters and teachers unions threatened to fund a campaign to defeat Proposition 5. Realtors argue that seniors living in high-valued homes with low assessments are trapped in their homes, and Proposition 19 frees them from this financial burden. Well, actually, first-time home buyers are the ones trapped out of home ownership. Firefighters and teachers unions told the realtors that unless they found the revenue to offset the loss, that they would once again fund a campaign to defeat a new proposition, just as they had successfully defeated Proposition 5. So the California realtors had to find a major source of revenue to pay for the huge loss of revenue created by a universal Prop 90, available in all 58 counties. They decided on eliminating a tax loophole, the parent-to-child transfer inheritance exclusion. In 2017, California's independent legislative analysts issued a scathing report on the inheritance exclusion, Proposition 58, whereby children are able to inherit their parents' principal residence and retain their low assessed value. The LAO estimated that 60 to 80,000 property owners had received this benefit at a cost of as much as $1.5 billion in lost property tax revenue annually. In addition to the transfer of the principal residence, Proposition 58 also allowed the transfer of additional property assessed at $1 million. Well, the LA Times did a serious investigation revealing the absurdity of this loophole. The Times reported how celebrities Beau and Jeff Bridges had inherited a 4-bedroom Malibu home from their actor father Lloyd Bridges with access to a semi-private beach, panoramic views of the Pacific Ocean. The investigation revealed that the Bridges rented the home for $16,000 a month and paid approximately $5,000 a year in property taxes. Candidly, the California realtors didn't really care that much about this part of Proposition 19. They just needed to find $1 billion to offset the $1 billion lost from a universal Prop 90. Well, almost immediately, assessors and more powerful interests like the California Farm Bureau identified major problems with the language of Proposition 19. Farmers who historically passed the family farm from generation to generation recognized that they would be big losers. With major political problems building and the likelihood of an organized, well-funded opposition from farmers and labor unions, the realtors asked the legislature to step in and fix the problem. In just 6 days, a half-baked Proposition 19 passed the legislature, mostly behind closed doors. It was so late in securing legislative approval that the governor had to step in and sign special legislation tolling the required deadline in which an initiative must be approved by the legislature. Well, the result was a mess. California assessors and the State Board of Equalization have been scrambling to interpret Proposition 19 and determine how we will implement it. More than anything, assessors want to make sure that we uniformly and fairly implement all tax laws. Equal application is not just a goal for assessors, it's a fundamental axiom. A property should receive the same treatment no matter where it's located. Subject matter experts in the assessors' offices in Los Angeles, San Bernardino, San Luis Obispo, and Santa Clara, together with the State Board of Equalization, have been meeting to clarify and identify problems that must be addressed by the legislature and the BOE. Although not ideal, the legislature did provide the legal authority for assessors in the BOE to act. Proposition 19 limits eligible homeowners defined as over the age of 55, severely disabled, or homes destroyed by wildfire or disaster to transfer their primary home's assessment to a replacement residence of any value anywhere in the state. Now I'd like to introduce Nora Galvez on my staff. She is one of the state's leading experts in the transfer of ownership and currently oversees a team of assessment professionals responsible for reviewing 70 to 90,000 deeds annually in my office and determine which ones are subject to reassessment. Nora?
Good morning, everyone. Thank you so much for that introduction, Mr. Stone, and thank you to all of you that are participating in this webinar. So yes, I would like to give you just a quick overview of where we are in regards to Proposition 19. But before I do that, let me just give you a very quick overview of Proposition 58, the parent-to-child transfers and the grandparent-to-grandchild exclusion transfers. So Proposition 58 was effective on November 6, 1986, and it's added by Section 63.1 of the Revenue and Taxation Code. Under Proposition 58, the parent-to-child transfers of principal residence between parent and children are allowed without reassessment, of course, as long as the provisions of 63.1 are met, regardless of the value of the principal property. There are no restrictions of the use of the property. So a property can be the principal residence, it can be a commercial property, or it can also be an income property. But also it has the $1 million in assessed value on properties other than the principal residence. So a parent can inherit or transfer or sell to the children 5 homes. One is the principal residence, the other 4 is income property, as long as it doesn't exceed $1 million limit. That was allowed under Proposition 58. Grandparent to grandchild was effective on March 27, 1996, and is also under Section 63.1 of the Revenue and Taxation Code. Under grandparent to grandchild exclusions, transfers of principal residence between grandparents to grandchildren are allowed only, and that is a key here. So it's only one way, okay? Without any reassessments, regardless of the value, of course, again, as long as the statutory requirements are met under grandparent to grandchild, Section 63.1. And there's no restriction of the use of the property also after the transfer. One of the statutory requirements for the grandparent to grandchild is that the middle generation has to be deceased. So in order for the grandchildren to qualify, the parents of the grandchildren have to be deceased. So that is Prop 58 and 193 prior to Prop 19. So then now, Prop 19. Prop 19, as all of you know, it was approved by California voters on November 3rd, 2020, and it adds Section 2.1, 2.2, and 2.3 to Article 13.8 of the California Constitution, and it modifies the parent-to-child exclusions provisions, the base year value transfer provisions, and it also established the California Fire Response Fund and County Revenue Protection Fund. So let's look at the parent-to-child transfer exclusions, which is also known as intergenerational transfer. So perhaps you might heard that term already. So it limits exclusions to family farm or family home only. The family home has to be the principal residence of the transferor and the transferee. Other real properties do not qualify. So remember, as I was saying, under Proposition 58, the parent can have 4 income properties and a commercial property. So under Proposition 19, that's not allowed anymore. Only the family home or family farm. And it also adds a value test to the family homes. Okay, and I'll talk to you in a little bit about the value test because it's important to know. So eligible transferor and transferee. So the transferor is the person that is giving away the property, and the transferee is the person that is receiving the property. So an eligible transferor and an eligible transferee have the same meaning under Proposition 19 and are defined as a grandparent, a parent, a child, or a grandchild. So this means that the exclusion applies to a parent-to-child transfer of real property in either direction, from a parent to their children or from the children to their parent. Under certain circumstances, it is also applies for exclusions from grandparent to grandchildren on either direction, or from grandchild to grandparent. And remember, under Proposition 193, that was not allowed. It was only one way. But under Proposition 19, it is allowed. So it goes both ways in either direction. Okay. So let's look at the family home. Well, the family home, it must be the principal residence of the eligible transferor, and the eligible transferee must use the property as his or her principal residence within 1 year of the transfer. So again, this is very important because under Proposition 19, it is only the principal residence that is being allowed to qualify for these transfers. And it has to be the principal residence of both the transferor and the transferee. So the principal residence of an eligible transferee must establish the principal residence within that 1 year of the transfer date. So that means that the homeowner's exemption or the disabled veteran's exemption needs to be applied, needs to be in file in our office within that 1 year of the transfer. This is in addition to the filing requirements, which is 3 years under the statute of limitations. So let's look into that. So the filing requirements, like I said, it is 3 years from the date of the transfer or before the transfer to a third party. However, if the transfer it is transferred to a third party, the claimant still has 6 months from the notice of supplemental or escape assessments to qualify. But then also, if those 3 qualifications are gone, those filing requirements are gone, if they still entitled, they still can file for a prospective relief for the lien date of the year where the form is filed in our office. Okay, so they still have that last opportunity to file for the exclusion. And I just kind of want to mention that these 3 requirements are also the same as Proposition 58 and 193, so that did not change. So just looking at the differences, the comparison between Proposition 58 and 193 and Proposition 19, I thought that this was very helpful. So I included these comparison chart to all of you so you guys can see that. This is also on the State Board of Equalization website for you guys to see. So in here you can see the difference, the principal residence under Proposition 19, the family home or farm only. Under Proposition 58, 193, that $1 million exclusion on other property was completely eliminated. Okay, grandparent to grandchild, you can go both ways, but the qualifications remain the same. The middle generation has to be deceased in order for the grandchildren to qualify. The filing period, the homeowner's exemption, again, within that 1 year, and the 3-year statute of limitations still applies, the same as Proposition 58. The section where you can read about Proposition 58 and 193 and all of the requirements are under Section 63.1. Under Proposition 19, which is a new revenue taxation code for us, is 63.2. And the important dates to remember is that Proposition 19, the intergenerational transfers, is effective transfers on or after February 16, 2021. And just as a note, really quickly, I just wanted to say that we are still receiving claims for Proposition 58 and 193, as long as the transfer day is February 15, 2021 or prior. We're still looking at those forms and excluding taxpayers from reassessment under that exclusion. Okay. So the value test, like I mentioned. So this is very different for us as when with the implementation of Proposition 19, the intergenerational transfers. This value test was added, which is we have to calculate the sum of the factor base year value plus the $1 million that is Proposition 19 is giving to a taxpayer. We have to determine whether the assessed value exceeds the sum of the factor base year value plus that $1 million. We have to calculate the difference, and then we have to add that difference to the factor base year value. So it's completely different as to the way that Proposition 50 and 193 works. So let me give you an example of that, okay? So let's just say that there's a death, and that is the transfer date, the date of death. So it did occur on April 3rd, 2021. The parent was paying taxes based on $348,000. So that's the factor base year value. Well, the fair market value, the new base year value of this property is $1.8 million, okay? So let's do the value test here. So we are going to add the factor base year value plus the $1 million in exclusion that Prop 19 is giving. So that is $1.3 million, okay? So then now let's do the comparison. So we're doing the fair market value minus the sum of the factor base year value plus the $1 million that equals to $451,679,000. Okay, so now we're gonna see the difference, and we're gonna add it to the current factor-based year value. So in this case, the new taxable value, so this child, if this child inherit the property or a grandchild inherit the property, they're going to be taxable. The new taxable value is $800,000 compared to Proposition 50A and 193 that perhaps this child could have retained the $321,000 factor-based year value. So that is the difference in between Proposition 50A and Proposition 19. So in this case, like I said, the child, the grandchild is not able to keep fully the factor-based year value where the parent or the grandparent was originally had on the property. Okay, so let me give you a second example, which is actually the opposite. So on this scenario, the transfer day is June 2nd, 2021. The factor-based year value for this property is $825,000. The new base year value for this property, the fair market value, is 1.5. So let's do the calculations again. Factor-based year value plus the $1 million. And then now we're going to do the difference between the factor-based year value and the $1 million minus, we're going to do the fair market value minus the sum of the factor-based year value plus the $1 million. And we can see that there is a minus of $325,000 here. So the market value does not exceed the excludable amount. So in this case, the person that inherited this property, because it's a death, is actually going to be able to retain the fair market value, the factor-based year value that the parent or the grandparent actually had in the property. So in this case, there will be no changes to the value. They will continue to have exactly the same. Okay, so I hope that was helpful for all of you in regards when we're going to be adding value to the factor-based year value and when actually a taxpayer is going to be able to keep the same factor-based year value moving forward. Okay. Okay, so now let's get into the base year value transfers. Okay. So let me give you just a little bit, few dates for you to remember. I know Mr. Stone went over this briefly. Proposition 60 is effective November 5th, 1986. Proposition 19 on November 9, 1988, and Proposition 10 on June 6, 1990. So let's look at the some of the qualifications. Again, I know you heard this from briefly from Mr. Stone, but the basic eligibility under Proposition 6090 is that it's any person over the age of 55 years or any severely or permanently disabled person who resides in the property and is eligible for the homeowners exemption. So that means that this property is the principal residence of this person, and so they may transfer their value, the assessed value, to another home, subject to the conditions and limitations of Section 69.5, which is the Revenue and Taxation Code, where you can find the eligibility and everything that you need to know about Proposition 60 and 90. So they can transfer the base year value to another property, another replacement property, another dwelling of equal or lesser value that is located within the same county, but also to those other counties where an ordinance allows for this type of transfers, okay, within 2 years of the sale of the home, okay? So let's look at what is the difference on Proposition 19. So under Proposition 19, the base year value transfers, they were enacted on April 1st, 2021. and it's only one of the only one of the transfers can occur on April 1st of 2021. So it can even be the sale or the purchase of the replacement home. It can be either or that happened after April 1st, 2021. Okay. A claimant can utilize this benefit up to 3 times. And this is a big difference because prior to Proposition 19, these very base year value transfers were only allowed once. So under Proposition 19, it's allowed 3 times. Okay. And any eligible to transfer to all 58 counties in California. As before, like I mentioned, it can be transferred to other counties as long as they had an ordinance on file, and I believe it was 10 counties that had that ordinance before. Something to add here is that I would like to mention that is important is that there's no value limit. As before, there was the purchase of the replacement home for lesser, equal or lesser value. So in here under Proposition 19, there's no value limit. Okay, which again is one of a big difference here. So, so the requirements for the original property and the replacement property is that the claimant, the taxpayer, has to be entitled of this property, the original property, and when they purchase the replacement home, they also have to be the owners on title. And both properties, they had to be used as the principal residence. The original property and the replacement home has to be the principal residence. So a homeowner's exemption needs to be filed also. Okay. So the filing requirements under Proposition 19 base year value transfers. So it is within 3 years of the replacement property transfer date of the new construction. If a claimant filed after the 3 years, relief is granted at the beginning with the calendar year in which the claim was filed. And under Section 69.5, which is the section that was added, that describes base year value transfers under Proposition 19. Under that section, a spouse of a claimant who is a record owner of the replacement dwelling is not considered a claimant for the purposes of this section. So this means that a spouse or a registered domestic partner may each transfer the base year value 3 times. And this is a big difference because before this was not allowed. So that's something to keep in mind. So I also included this comparison chart for you guys to see. And again, this might be maybe a little much helpful for you guys to see the difference as to before and after. The principal residence, that did not change. The timing, it is still within the 2 years. Something that did change, it was the same county or those counties that had that ordinance allowing for these transfers. Now under Proposition 19 is anywhere in California. The value limit before equal or lesser value on the replacement home. And then under Proposition 19, there's no value limit. How many transfers can be done? Under Proposition 90, 1 time. Under Prop 19, 3 times. The statutory, the section code, 69.5 under Proposition 60 and 90. Under Proposition 19 is Section 69.6. And the important dates to remember is that Proposition 19, base year value transfers, the effective date is April 1st, 2021. Okay. So I wanted to give you just a couple of examples also when it comes to those, how is it that we're going to calculate these base year value transfers? The same as the intergenerational transfer on that slide, I also included an online estimator that we have in our website for you guys to, to see, to check it out. You actually can do your own calculations. And like I said, I believe it's going to be on the chat, and it is on our website. Okay. So now let me give you one example. Okay, so example number one. So the original property, the sale of this property was on June 2nd, 2021. The factor-based year value is $825,000. The full cash value of the original property is $1.5 million, okay? So now let's look at the replacement property. So the purchase is on July 2nd, 2021, okay? The full cash value is 1.3. And as you can see, you know, the dates, at least one of them, actually in this case, both of them occurred on April 1st, 2021. So we're good. So now let's look at the calculations. So we are doing the full cash value of the replacement home minus the full cash value of the original property, which is minus $200,000. So the full cash value of the replacement property does not exceed the full cash value of the original property. So in this case, $450,000 is enrolled as the new taxable value for the replacement property. Okay. So now let me show you a second example, okay, which is actually different. So the original property, again, the sale occurred on June 2nd, 2021. The factor-based year value for this property is $825,000. The full cash value is $1.5 million. The replacement property, the purchase, July 2nd, 2021, the full cash value is 2.3. So doing the calculations, we take the full cash value of the replacement property minus the full cash value of the original property, and that equals to $800,000 in excess value. So the full cash value of the replacement property in this example does exceed the full cash value of the original property. So $825,000 plus the excess value of $800,000 equals to $1.6 million. So that's the amount that we're going to be enrolling as the new taxable value for the replacement home. So again, I hope that these examples are helping just to kind of give you an idea of how we are actually implementing, the values on the replacement property. Lastly, I just kind of want to let you know that we do have really good resources. Here is a BOE website where you can see all of the guidance when it comes to Proposition 19 and also the legislation. You can look at it. There's a lot of good information. There's questions and answers that the BOE has posted, but then also as a reminder, we also have good information on our website that you also can check and see. And now I would like to open to all of you and see if you guys have any questions in regards to Proposition 19, intergenerational transfers, base year value transfers. I just kind of want to briefly state that we also have Audrey Atkins and Debbie Chavez from the Real Property Division. They're also experts on base year value transfers, and they will be able to help you out with any questions that you may have.
And just a reminder, thank you, Nora. Just a reminder too that our office is prohibited from giving legal advice. The information presented today and answers are meant to be a general summary of Prop 19. And if there's a conflict in the information provided, then the proposition or any legal authorities implementing or interpreting the proposition, the text of the proposition, and other implementing or interpretive authorities will prevail. So thank you. Okay, so we've got a question. If we can define full cash value, please.
Full cash value is the fair market value of the property. So basically what you purchase it for and if the appraiser has accepted the sale.
Great, thank you. Any other questions? Again, you can post them in chat to everyone, or you can post them just to the hosts and panelists. And all of this information we'll be sharing. This presentation is available on our Facebook. We'll also be sending out a link to the video, as well as sending out some resources. We'll send out all the links that we've provided in chat. And then we've got a question from about how does Prop 13 play into Prop 19?
Hi, Karen. Prop 19 is a little bit different than Prop 13. So Prop 19 just allows people 55 and older who have a primary residence to transfer that tax base to another primary residence anywhere in California. Prop 13 is just when you own the home, those taxes aren't allowed to go up more than 2% per year. So they are a little bit different to that degree.
And so if you do not apply for any of the provisions of Prop 19, then the Prop 13 provisions would apply to your assessment.
Great. Any other questions? Okay. Okay, so we've got to thank you for that. Okay, for that answer. And again, you're welcome to, I did post our link to our Prop 19 overview. We've got the calculators, that the link's also there. We've got some great information on our website that's helpful. Our subject matter experts are always available via email or phone during the week to answer questions that you might have. We understand that circumstances may be individual. We're just launching a poll now. So if we've got a one single question poll, would an additional webinar on Prop 19 be of interest to you? So if you would like to complete that poll, that would help us understand what information we need to help provide to the community to make sure that they have the detail that they need. And we'll just end that in just a few seconds. We're getting close to the participation rate. We'll give that about 15 more seconds. Wonderful. Thank you for those who participated in the poll. I'm going to now hand this, and thank you to our presentation from our team, our Nora Galvez, our division chief for standard services and exemptions. That was a lot of information, and consider our team as a resource to you should you have more questions. And now I will turn it back to Assessor Stone for closing remarks. Thank you.
Well, thank you very much for participating. We will try to do more of these webinars on relevant topics that come up. My office stands open to questions and concerns. I would just like to say one thing, that the assessor, in this case, and assessors throughout the state, are interested in only one thing, and that is accurate assessments on the assessment roll. We do not pay attention to the revenue that would be generated. A good example of that is the Great Recession of 2008. My office proactively reduced the assessed value with the collapse of the residential housing market that caused the recession, the Great Recession. We proactively reduced the assessed value on 136,000 properties. Took 27 billion off the assessment roll. The assessment roll was reduced by 27 billion. And we did that without a request on the part of the property owners, because we had to reflect. It was necessary for us to do our job to reflect the collapse of the market. We then, as the market improved, clear from that point in time, 2009, 2010, up till 2015, when the Great Recession essentially was declared over. We restored most of those property values at that time. So we're only interested in putting accurate values on the roll on an annual basis. The assessor is constitutionally required to close the assessment roll with all property, business and personal property, as well as residential, as well as real property every July 1st. And so everything crescendos up, if you will, in my office from the valuation date, what we call the lien date, but the valuation date of January 1st. So this year, we will close the assessment roll again on July 1st based upon values in place as of January 1st of this year. I want to thank you for joining us today. As she mentioned, there's a lot of resources available, and we hope you will take advantage of them. Thank you, and good morning.